Yeah, she's like a very much. So you're talking
Yes.
that one should be wired. Very good. So they are
But she wanted to.
And you better just stay in the job for a while. Trouble. Yeah. So if you had some This is just the 5 in the Washington DC area. So that was 500. So we were able to get 3 vendors. Under ideal. Yeah. Anyhow, they built that. No. Congratulations. No problem.
All rise. Please be seated. Would the agents for the argument step forward? So could you explain how you're dividing your time?
Certainly, Your Excellency. We're both splitting our arguments 14 minutes each with 2 minutes for rebuttal.
Your Excellencies, we're splitting our arguments 15 minutes, then 13 minutes with 2 minutes for rebuttal.
15, 13, and
2. Yes, sir.
okay, let's begin. Would you approach the bench?
Excuse me, I have to talk to Skip, please.
Why don't you take a seat? Are we ready to proceed? Okay, please approach the bench. Mr. President and Your Excellencies, may it please the Court. My name is Brad Powell, and together with my co-agent, Rebecca Mills, we represent SPIDER, the Sovereign People's Independent Democratic Republic, applicant in this matter. I have requested 14 minutes to address the first issue, Adventura's liability for the complete destruction of DROPCON. And my co-agent has requested 14 minutes to address the second issue, Adventura's liability for the damages to SPIDER's spacecraft. And we have reserved 2 minutes for rebuttal. Would the Court prefer a brief recitation of the facts?
You may.
Your Excellencies, when Adventura relaunched Tyrus from Floyd 4, it knocked over the Nude 1, resulting in its inoperability. It then rendered the surface of Floyd 4 in such a state as to cause damages to the Nude 2 spacecraft when SPIDER attempted to consequently land there. When the Tyrus spacecraft went to SID-1, it attempted a gravity tractoring mission that failed. Rather than steering the asteroid clear of the Earth, the asteroid directly impacted over DROPCON and decimated the town. Your Excellencies, this case demonstrates the dire consequences that result when one state, acting of its own volition, attempts to serve as master of the heavens.
What if the motivation for that state was humanitarian?
Excuse me, Your
What
Excellency?
if the motivation for that state in acting unilaterally was humanitarian?
Your Excellency, motives in a court of law have never precluded the wrongfulness of the conduct. Good intentions, for instance, do not make Adventura or any other respondent not liable for their conduct.
But was there not a duty to move the astronaut once they had knowledge of the likely impact through the keyhole on the Earth?
International law does not recognize any such duty, Your Excellency. At present, the duties that international law recognize are duties of cooperation and consultation and considering due regard for the interests of other states and conducting missions with due diligence so that you don't expose other states to greater degrees of risk.
But Agent, that may be the case at space law. What about humanitarian law?
Humanitarian law, Your Excellency, actually relates to principles of the use of armed force. In this case, this is an exceptional case where principles of humanitarian law with respect to human rights, with respect to the scope of uses of armed force, would be inapplicable and not tested. And this simply is not a case of humanitarian law. It's one of space law. And we have treaties that we can use to interpret the consequences of this case.
Okay, why don't you proceed to wrap up the facts and then move into your arguments?
Yes, Your Excellency. Adventura sent SID-1 on a collision course for DROPCON, and consequently, the town was decimated with a force 140 times greater than the bombing of Hiroshima. International law requires that Adventura be held liable. Specifically, SPIDER offers 2 theories of liability. As I mentioned, under the treaties, the Liability Convention, Article 2, holds Adventura absolutely liable. And alternatively, second, Adventura is also liable as a matter of customary international law because its wrongful conduct resulted in the destruction of the town. To begin then with the Liability Convention, Article 2 requires that states be held liable, absolutely, when their space objects cause damages to the surface of the Earth.
Is the asteroid a space object?
No, Your Excellency. Under the framework of the treaties, the asteroid would be seen as a celestial body. However, the Tyrus spacecraft is the space object in question before this court. The elements of Article 2 liability are 4. First, the state must be a launching state of the object in question. That object, as I mentioned, must be a space object. Third, that space object must have caused the damages. And fourth, those damages must be compensable under the treaty. With respect to the first element under Article 2 of the Liability Convention, Adventura is the launching state of Tyrus because it launched the spacecraft from its own facilities and by its own space agency within its territory. This satisfies the definition under Article 1 of the Liability Convention of a launching state. The second element under Article 2 of the Liability Convention requires that this object be a space object. Here, since it is a spacecraft meant to move and operate in outer space, the ordinary meaning of the treaty term would suggest that this is in fact a space object. Third, with respect to causation, Tyrus caused Spider's damages. Spider offers two theories of causation. First, but for Adventura's redirect mission, these damages would not have occurred and drop gum would still be on the map today. Specifically,
Is that established as a fact or is that a probability?
Your Excellency, Adventura, when it sent Tyrus to SID-1, confirmed using transponder data concerning the asteroid that the nominal impact point would occur over the middle of the cold ocean.
But that was still a projection.
Yes, but it was a
It
much
was not
more...
a fact.
It is a fact as stated in the compromis at paragraph 19. It was confirmed that SID-1's nominal impact point would be in the middle of the cold ocean.
Correct.
This is prior to the redirect mission.
Okay.
Therefore, because it was confirmed in the compromis that the nominal impact point would be over the center of the cold ocean, but for this mission, the damages would not, the SID-1 would not have impacted directly over drop gum.
Agent, you're not equating the but-for test with fault, are you?
No, Your Excellency. Specifically under Article 2, this is not a fault-based regime, simply a strict liability regime.
But doesn't strict liability apply to aircraft in flight and the terrestrial surface of Earth?
Yes, Your Excellency, and that is subsumed within the meaning of Article 2, where it applies to damages that occur on the surface of the Earth or to aircraft in flight. Here, the resulting damages decimated a town. Therefore, that is damages on the surface of the Earth, as implied by Article 2 of the Liability Convention. The second theory of causation that could be applied for Adventura's gravity tracking mission is one of proximate causation. Specifically, because Adventura chose to accelerate SID-1, moving the asteroid closer to Spider rather than away from Spider, it is foreseeable that any failed mission would in fact result in damages to the territory below that impact point of the asteroid. The highly qualified publicist...
And Agent, if it was foreseeable, did that give rise to a duty?
The duty, Your Excellency, exists independently from the Liability Convention. The Liability Convention is not a convention that requires a showing of unlawfulness. A state could act lawfully and still be absolutely liable for its space object. The duties that frame this idea are that space and operating in space is ultra-hazardous, and states must assume the risks of their operations in space. And if they result in damages to the surface of the Earth, they're absolutely liable. With respect to the theory of proximate causation, the scientist Rusty Schweikart, who is a specialist in near-Earth object threat mitigation and the gravity tractoring concept, has written specifically that the risks of a failed mission specifically include causing harm to populations and property that would otherwise not be at risk. Therefore, Adventura's mission was foreseeable, the damages were foreseeable, and the mission was the proximate cause of those damages.
Agent, let me take you back to the motivation, though. The intention, if I understand it correctly, was to prevent the asteroid from hitting the Earth at all. Is that correct?
That was one intention, Your Excellency, but the intentions were threefold. First, Adventura was attempting to prove its gravity tractoring capabilities. It had never tested these capabilities before. Second, if those capabilities could be in fact proven, presumably the mission would have succeeded. However, the mission did not succeed. Adventura's third intention was to mine SID-1 if the mission had succeeded.
But with regard to the effort to move the asteroid, it was to prevent it from hitting the Earth altogether. Is that
Certainly,
correct?
Your Excellency.
Okay. So the mere fact that damage doesn't occur does not necessarily establish that it was a failure to observe the necessary standards, does it?
Could you clarify your question by the mere fact that damages doesn't occur?
No, damage did occur.
Yes.
The fact that damage did occur doesn't necessarily establish that there was a failure to observe reasonable standards, in this case, an attempt to move an asteroid that was confirmed to be likely to hit the Earth.
That is correct, Your Excellency, and this moves into Spider's alternative theory of liability, how Adventura is liable as a matter of state responsibility for wrongful conduct. There are two issues as to why Adventura is responsible in this manner. First, they did not act with due diligence as required under customary international law principles. And second, they violated the duty under Article 9 of the Outer Space Treaty to act with due regard to the corresponding interests of all other states. With respect...
Agent, is there a difference between due diligence and due regard?
Yes, Your Excellency. Specifically, as a basis of law, due diligence arises out of the general practice of states and as reflected in this own court's jurisprudence. However, the duty of due regard arises out of Article 9 of the Space Treaty, and therefore it is an issue of treaty interpretation. But the concepts as between due diligence and due regard are quite similar. With respect to due diligence, this court confirmed in its nuclear test cases when France attempted to conduct atmospheric nuclear tests that impacted Australia and New Zealand, that states must ensure that activities within their control respect the territory and environment of other states. In effect, this obligation is akin to a reasonableness standard. Here, had Adventura conducted a thorough risk assessment, communicated and consulted with Spider prior to making the decision to put Spider at greater risk, and had Adventura avoided acting too hastily, we would not be here today. Near-Earth object threat mitigation is an inherently international activity. This is why, as parties to the UN Coppice Group on Near-Earth object threat mitigation, on Near-Earth objects, that body has proposed principles and procedures that they have submitted to the UN General Assembly by which states ought to follow if they're going to conduct these types of missions.
So they're not legally binding if you're saying they ought to follow.
Correct, Your Excellency. At present, those principles and procedures are not legally binding. However, the duty of due diligence as a general principle of law still holds. Because Adventura did not consult, communicate, because they acted too hastily, because this was a unilateral decision made with no input from Spider, nor with any...
Agent, what difference would it have made if they had consulted?
Your Excellencies, the difference would have been Spider would have at least had an opportunity to be heard. But nonetheless, even if Spider was able to consult and Adventura still chose to pursue the course of action that put Spider at greater risk, Adventura would not be off the hook. Adventura would still have the duty of reparation owed when states assume the risk of their conduct, and that conduct results in damages. Moving then to the second reason why Adventura violated customary international law, specifically the violation of the treaty requirement of due regard under Article 9 of the Outer Space Treaty was not followed here. Spider's interest was to minimize the risks of a failed mission and prevent its territory from being exposed to greater harm. Adventura, however, decided to station Tyrus ahead of SID-1 when it could have stationed Tyrus behind SID-1. In effect, it exposed Spider to greater risks despite the fact that it was unilaterally choosing to undertake this mission without consultation. Here, if one state is going to unilaterally take this type of mission in a manner that unequally exposes other states to harm and fails to consult with other states, then it must assume the risk of liability. Had Adventura not breached these obligations, the damages to Dropcom might not have occurred. Spider would have had a chance to express its concerns, to weigh in and share with Adventura why a more prudent course of action would be first to get the full international, I see my time has expired, thank you, would be to get the full international community's approval of this mission and move the asteroid so as not to put others at greater risk. Thank you, Your Excellencies.
May it please the Court, my name is Rebecca Mills, agent for the applicant. I will be addressing the second issue before the Court today, liability for the damage to the Nude-1 and the Nude-2 spacecraft during the course of their activities on the Floyd 4 asteroid. Adventura is liable on two legal bases. First, it is liable under Article 3 of the Liability Convention, and second, it is liable under the customary doctrine of state responsibility. For the sake of clarity, I will first address liability for the first spacecraft, Nude 1, and then I will turn and address liability for the second spacecraft, Nude 2. Beginning with Nude 1, Adventura is liable under Article 3 of the Liability Convention. The three relevant elements are 1, that the launching state's space object caused the damage, 2, that the damages Spider seeks to recover are compensable under the convention, and 3, that Adventura is at fault. Turning to the first element, Adventura is the launching state of TIRUS, which is a space object, and caused the damage to the Nude 1 spacecraft. As my co-agent has explained, Adventura is the launching state because TIRUS was launched from within Adventura's territory, and because Adventura has procured that launch. And TIRUS is a space object because it is a spacecraft designed to move in outer space.
Agent, how have they procured the launch? Could you explain that to me?
Yes, Your Excellency. Though the URA consortium was also a participant in this particular activity, Adventura has procured that launch from that particular consortium, and therefore, whether the launch can be seen as a launch of from Adventura or from orchestrated by the URA consortium, Adventura is nevertheless the launching state in both circumstances.
Does the UARC have a legal personality?
Yes, Your Excellency, it is an intergovernmental organization led by Adventura.
It's a consortium.
Yes, Your Excellency.
A legal personality would have some incorporation. It would exist under international law or domestic law. What domestic or international law does the consortium exist under?
Your Excellency, the compromise does not indicate those particular relevant facts about the consortium, simply that Adventura is the lead state of that consortium and that it is made up of a number of spacefaring states for the purpose of anti-NEO threats.
So we don't know whether it can act as an entity.
No, Your Excellency. Returning again to the first element, TIRUS caused the damage to the Nude 1 spacecraft as read in paragraph 19 of the compromise, which states, the TIRUS relaunch from Floyd 4 took place, however, the Nude 1 was knocked over in the process, and its antenna was oriented down toward the surface of the asteroid. This resulted in the loss of all communications to and from Nude 1. Moving then to the second element, by knocking over Nude 1, TIRUS rendered Nude 1 inoperable.
Agent, is there anything in the compromise that would indicate the reorientation of the antenna was the result of fault?
Yes, Your Excellency. In paragraph 19 states that TIRUS knocked into the Nude 1 spacecraft and thereby caused the loss of the communications. In the factual clarifications, paragraph 12, this resulted in the loss of all operability of that Nude spacecraft. Adventura is at fault in this case because it has breached its violation of Outer Space Treaty Article 9, which requires a duty to consult when there is risk of harmful interference. Because Adventura did not consult when it was attaching to the preferred attachment site where the Nude 1 spacecraft was located, it is at fault for breaching that provision of the Outer Space Treaty, Your Excellency.
But Agent, isn't this a difficult asteroid to launch on? And can states really control, based on the facts of this case, where the spacecraft actually sets down on the celestial body?
Your Excellency, no, not necessarily. There are difficulties in attaching to an asteroid, but this is precisely the reason why Adventura should have anticipated that TIRUS would create the risk of harmful interference to Nude 1 when it attempted to land at a site in proximity to the Nude 1 spacecraft. In the case of complications, as TIRUS did encounter, it may have bounced when it hit the surface.
So your argument is harmful interference and not failure to consult?
Your Excellency, my argument is that because there was a risk of harmful interference, there is a duty to consult under Article 9 of the Outer Space Treaty. By failing to consult with Spider, Adventura breached that duty, and the resulting harm was harmful interference with the Nude 1 spacecraft. Returning to the second element, because the Nude 1 spacecraft was no longer of value to the Spider Space Agency without its functionality, that constitutes damage to a space object per Article 3 of the Liability Convention. Moving then to the third element, which I have just discussed, Adventura is at fault for that breach of Article 9 of the Outer Space Treaty by failing to consult with Spider. This brings me to the second theory of liability. Adventura is also liable under the customary doctrine of state responsibility. Like the notion of fault under the Liability Convention, under the doctrine of state responsibility, an injured state must prove that the acting state has violated its international obligations. In this case, Article 9 of the Outer Space Treaty.
Agent, is liability and responsibility the same thing?
Yes, Your Excellency, under the doctrine of state responsibility, and as held by this court in the Corzau factory case, the violation of an obligation entails the responsibility to make reparations, and that is liability in international law. Because Adventura has breached Article 9, it is therefore liable under the customary doctrine of state responsibility and must make reparations to Spider.
But agent, responsibility has a specific meaning under the space law treaties in Article 6 of the Outer Space Treaty. And that responsibility is what?
Your Excellency, a state is responsible for its national activities in outer space. Because this activity was carried out by the federal URA Space Agency, it is a national activity. Moreover, even if this court were to consider that activity to have been the activity of the URA consortium, even under Article 6, international organizations, the actions of international organizations are also the responsibility of member states.
But aside from your argument under the Liability Convention, the responsibility with regard to private actors or actors from the state is to authorize and supervise. Is that correct?
That's correct, Your Excellency.
And did UARC authorize this launch?
Your
I believe
Excellency,
it states that they did.
yes, the launch
They
from
licensed
Void
it.
4.
Right. And did they supervise it?
Your Excellency, the compromise does not.
But they controlled the launch. It was their, they controlled the spacecraft. They controlled the landing on the planet, correct?
The federal URA.
Yes.
Yes.
So why is that not a discharge of their responsibility under the Outer Space Treaty?
Your Excellency, the Outer Space Treaty under Article 7 makes the state liable for the damage resulting from its space object. In this case, because the TIRUS space object caused damage to the Nude 1 space object, it is therefore liable under Article 7 of the Outer Space Treaty.
Correct. It's liable for damages based on the 4 prongs of the treaty. But why is it a breach of their international responsibility?
Your Excellency, it is a breach of their international responsibility because they have breached the Outer Space Treaty Article 9 for their duty to consult with Spider. Moving then to the Nude 2 spacecraft, again, Adventura is liable both under Article 3 of the Liability Convention and the customary doctrine of state responsibility. Beginning with the Liability Convention, first, Adventura's TIRUS space object caused the damage. Second, the loss that Spider seeks to recover is compensable. And third, again, Adventura is at fault. Beginning with causation, TIRUS caused the damage to the Nude 2 spacecraft when, as it was attempting to attach to the Floyd 4 asteroid, it altered the surface of that asteroid and thereby violated the structural integrity of that particular spot at the preferred attachment site.
Agent, where's the fault in that?
Your Excellency, the fault is the violation of Article 11. Article 11 requires that states report to the Secretary General the results and conduct and location of their missions in outer space, as well as to the general public. By failing to do so, Adventura ensured that Nude 2 would encounter the same difficulties when it was attaching, unaware of the increased risk that were represented at that particular spot compared to when it had originally attached with its Nude 1 spacecraft. Returning to the first element, as stated in paragraph 22 of the compromise, the physical structure of the surface had been altered due to TIRUS' previous efforts to attach to Floyd 4, and Nude 2 had a difficult time successfully attaching to the NEO. In the process, the scientific instruments which were planned to further investigate Floyd 4 were damaged irretrievably.
Agent, placing a space object on an asteroid is a very difficult thing to do. How do we know it's the change of the surface of the asteroid that is the issue? How do we know it's not the movement of the asteroid or the movement of the space object? How do we know it's not one of many other? Everything's moving very fast at the same time out there. How do we know it's the change of the surface that is the cause?
Your Excellency, because previously when SPIDER sent its first Nude 1 spacecraft, it investigated the properties, the rotational spin, the elements of this particular Floyd 4 asteroid, and it chose this as a suitable site to land its Nude 1 spacecraft upon. It therefore knew that it was a feasible site on this asteroid to land a spacecraft. Comparing the relative ease with which it was able to land the Nude 1 spacecraft at that attachment site with the heightened difficulty that it encountered after TIRUS had vacated that spot, is a reasonable inference that the damage occurred because of TIRUS alteration of that surface, thereby violating the structural integrity of the asteroid. This was a particular worry of the SPIDER Space Agency, as stated in paragraph 8 of the compromise. It asked states to consult with it before conducting activity on the Floyd 4 asteroid, precisely because it was worried that the structural integrity at that preferred attachment site would be compromised.
So, Agent, sorry.
No, you go ahead.
Would SPIDER have preferred that the spacecraft had been left on the asteroid?
Which spacecraft are you referring to, Your
The
Excellency?
UREC spacecraft?
No,
TIRUS, sorry, thank you.
No, Your Excellency, SPIDER would have preferred that TIRUS had not landed at that particular
Correct,
attachment
but the time
site.
you're talking about, it's on the surface of the asteroid, and you are now approaching it. You have a fair amount of information about what's on that asteroid, or you would not be able to land to begin with. So you're arguing that the movement of the subsoil caused the damage, and yet you're saying that the only implication would be if they had not moved, the damage would not have occurred. So what is your argument?
Your Excellency, it is true that the alteration of the surface is the but-for cause of the damage to the Nude 2 spacecraft. However, TIRUS did have a duty to leave, and it's the act of TIRUS...
It had a duty to leave?
Yes, Your Excellency, indicated by its acquiescence to leave the Floyd 4 attachment site and conduct its mission on SID 1.
Okay.
Agent, again, I asked this question before, but are you equating but for with fault?
No, Your Excellency. The but-for cause is the actual alteration of the surface, whereas the fault, which makes Adventura liable under Article 3, is the violation of Article 11. Both are necessary, and both are true in this case, and for both reasons, Adventura is liable. Turning then to the second element, at a minimum, the actual damage to the Nude 2 spacecraft, because it was damaged irretrievably in landing on this preferred attachment site, is compensable because it is damage to a space object. Additionally, the harvesting mission is compensable because it is property. I see that my time has expired.
Please finish.
Because it is property on board a space object, that is also compensable. Thank you.
Thank you. Okay, Agent for the respondent.
Could you state how you've divided your time again, please?
Yes, ma'am. I'm arguing for contention 1, and that's 15 minutes. My co-agent is arguing contention 2. That's 13 minutes. And the rebuttal is 2 minutes.
Thank you.
You may proceed. Thank you.
May it please the Court. Mr. President, Your Excellencies, good afternoon. My name is C.J. Robison, and I'm an agent from the United Republic of Adventura, otherwise known as URA. Today, I will explain why URA is not liable for the damage done to Dropcom by the Airburst of SID-1. My co-agent, Mr. Ian Perry, will then explain why URA is not liable for the damage done to the 2 Canute spacecraft. Therefore, I would like to reserve 15 minutes for my argument, 13 minutes for my colleague's argument, and 2 minutes for rebuttal. Thank you. URA is not liable for the damage done to Drop Gun by the airburst of SID-1 for 3 distinct reasons. 1, Spider cannot prove causation. Second, the liability convention in itself does not apply to this scenario. And third, because the liability convention does not apply, we can look to the general principles of international law to understand that URA acted correctly and legally within the constructs of necessity. Now, if we return back to the liability convention, we know that Article 2 states that a nation is absolutely liable for any damage a space object may cause on the surface of the Earth or an aircraft in flight. However, this does not exempt Spider, the applicant case, from having to prove causation. As this court held in 2015 in Croatia v. Serbia, a state that alleges a fact has the responsibility of proving that fact true. Now, Spider has said that because URA shifted the risk closer to the Spider coast, that this fact alone is sufficient to prove causation. However, in following this court's holdings, this is not sufficient to prove causation. In the case concerning pulp mills on the River Uruguay case, Argentina accused Uruguay of dumping dangerous nutrients in a river that caused an algae bloom. However, this court held that just because an algae bloom could be the natural result of such an activity, this was insufficient to prove causation, as there was already a natural risk of such a phenomenon occurring. Now, likewise, we are not equating an algae bloom with an asteroid impact. However, Spider has failed to acknowledge that Drop Gun was always at risk for impact or another natural consequence. As we know that SID-1, as it was coming close to Earth, there is a 1 in 650 chance that it would impact the Earth in itself. As it drew closer, there is a 1 in 80 chance that it would hit somewhere within the cold ocean. This not only included just the cold ocean itself, but included the coast of Spider, URA, and neighboring coastal states. Now, as URA was able to intercept SID-1, this 1 in 80 chance was reduced to the fact that SID-1 was indeed to impact the Earth, and action was necessary. Now, considering that Drop Gun was always within the uncertainty ellipse, that was at risk for not only an airburst, direct impact, but they could have also been at risk for a dangerous tsunami, even if URA had not intervened and allowed it to land in maybe the middle of the cold ocean.
Agent, was the only motivation to get to SID to move its trajectory so it would avoid hitting Earth?
Yes, it was that motivation. I believe that you may be referencing the compromise that URA may have harvested SID-1 if it was feasible. However, the compromise clearly states that URA's main motivation and intention in intercepting SID-1 was to indeed divert it away from striking the Earth.
Did the applicant agree with that?
Excuse me, Your Excellency?
Did the other side agree with that?
They may disagree with that, considering URA's may be actions on Floyd 4. However, this is not relevant, as the compromise clearly states that URA was first to intercept SID-1 to divert it, and then to harvest it if it was feasible.
Isn't intent something that the court decides?
Intent is something that the court decides? Not necessarily.
Or finds?
You are the finder of fact, and so you could imply that maybe there is intent, but however, we clearly hold the position that the intent was to divert SID-1 away from the Earth altogether. Now, if I may briefly return to the tsunamis, that in the fact that the Imperial College of London and Purdue University have used calculators that would demonstrate an asteroid of this size could cause a dangerous tsunami. Now, if URA was not to intervene, this tsunami could not only threaten Drop Gun, but the rest of Spider Coast, neighboring coastal states, as well as URA. And unfortunately, Spider has failed to acknowledge that SID-1 was a pre-existing risk regardless of URA's intervention.
Let us stipulate that that was the correct, and the motivation was correct. Did you have an obligation to consult the most immediately affected country, in this case, for Spider?
Of course, we had an obligation to consult, Your Excellency, but Spider would have this court believe that consultation is equated with permission. However, as Article 3 of the Outer Space Treaty allows us to do, we can look to international custom in order to interpret such provisions, such as the Article 9 provision on consultation. For example, the United States, when it realized that its defunct satellite, USA-193, posed a particular toxic risk to Earth, they informed the international community of the risks involved, and they also informed the international community of its intent to destroy the satellite. Now, like USA, in which they constantly informed the international community and other affected states of the risk and their intention to mitigate such risk, URA did the same thing in this situation. URA not only informed SPIDER of its intention to intercept SID-1, but as well as the risk involved with SID-1.
Did SPIDER request consultation?
SPIDER had many opportunities to request consultation, but however, they failed to do so when URA first announced that it would go to SID-1 to intercept it. SPIDER had ample opportunity to request more consultations in order to adequately research this particular threat.
So your argument is that you were not obliged to consult with them because consultations had not been requested, as they had not been requested in the U.S. satellite that was deorbited?
No, Your Excellency. We are saying that we adequately consulted in terms of what we would see in international custom, as general principles of international law allow a state to act independently in order to fulfill its legal obligations. As noted, publicist Ben Ching has announced that this is within the state's discretion as long as they fully oblige for their legal obligations. And URA, it is clear that they did so.
So are you saying Article 9 is inapplicable here?
It is not inapplicable, however, we fulfilled our consultation requirements under Article 9, Your Excellency.
And just to be clear, Agent, Article 9, I'm not sure you need a lot of help interpreting it. It says very clearly you shall, and that's the word in the article, undertake international consultations when there is reason to believe the activity would cause harmful interference.
And we certainly did, Your Excellency. We informed SPIDER and the international community not only of the risks involved with SID-1, but also our intent to deflect it. SPIDER had ample opportunity in order to come up with different solutions.
But doesn't consultation imply a two-way street? What you said you informed them, that's really a one-way communication. So how did you consult?
We informed through various press releases to SPIDER and the rest of the international community.
So informing is equated with consultation?
Yes, as we can see through international custom, variously through the United States. And we know that the United States and Russia and the former Soviet Union have a great impact on forming international custom in the realm of space. Now, if I may return back to the Liability Convention briefly, we can understand that the Liability Convention does not apply at all, as the Liability Convention assigns liability strictly to risks introduced by man-made space objects. We can look to the plain text of the Liability Convention to notice that a space object is defined as the object, its launch vehicle, and component parts thereof. The Rescue Agreement in Article 5 requires the return of such a launch vehicle and its component parts thereof. And the Outer Space Treaty under Article 7 assigns liability to objects launched into space.
Is there a definition in any of the space treaties of a space object?
No, Your Excellency, and this is not necessarily relevant to our argument, as we are simply demonstrating that the scope of the Liability Convention is strictly limited to risks introduced by space objects. And we know, at least, and that we agree with the applicant, that Tyrus in itself was a space object, while SID-1 was a celestial body.
But by your argument, it's not required that a payload be man-made, is it?
Excuse me, Your Excellency?
It's not a requirement that the payload itself be man-made. You said space objects are man-made. But by your definition, with no definition of space object and no mention of components, it's not absolutely correct under international law that a space object cannot be, can be something that is not man-made.
Well, Your Excellency, a space object, if maybe, though Article 31 of the Vienna Convention of All Treaties allow us to first interpret a treaty on its text, we can look to Article 32 of the Vienna Convention of All Treaties, which will go to Travaux Preparatoires, and that the drafters of the treaty did intend to assign liability to man-introduced risks into the outer space environment. For example, the Argentinian and French delegates were concerned about pieces being torn off and re-entering the atmosphere. Likewise, the Australian delegates were extremely concerned about, with man's entry into space, there would be ever-increasing risk. Now, we are not trying to assign liability.
Is this court bound by Travaux?
It is not necessarily bound, Your Excellency, but we know that the travaux préparatoire is a useful tool in allowing to interpret the treaty, and this court, in making the decision, is indeed bound by the constructs of the Liability Convention. Now, though we are not trying to argue that it's only limited to direct collisions or something from the space object resulting onto Earth, the scope of the Liability Convention is still yet not broad enough to encompass this situation. In fact, there is nowhere in the Liability Convention on its face that would talk about trying to mitigate a pre-existing risk, especially a natural one that threatened mankind as a whole. Now, if we were to take SPDR's interpretation of the treaty, it would be what the Vienna Convention calls a manifestly absurd interpretation. It would allow a state that took no action against a risk that threatened all mankind and allow them to reap the benefits of a state that took risk in order to comply with the spirit of the Outer Space Treaty to use space for the benefit of all mankind. Conversely, a state that took no action against such risks could punish and impute liability onto a state that acted within the spirit of outer space, trying to mitigate a pre-existing natural risk that threatened mankind. Consequently, Your Excellencies, the Liability Convention does simply not apply.
Agent, there's no international standard, and no international statute governing humanitarian assumption of risk or Good Samaritan conduct that would obviate any responsibility for having acted in this manner, is there?
Well, Your Excellency, we can maybe look to the law of the sea, maybe the UN Convention on the Law of the Sea, specifically UNCLOS under Article 98, that any vessel that might be in danger, that vessel is required to go about and rescue those individuals.
But this deals with a controlled environment, comparatively controlled environment, where there are many actors and many technologies to reach the vehicle. Here you're dealing with a hostile environment where there are very few people who can do that. So the question is, does the terrestrial ideas of humanitarian assistance or Good Samaritan coverage, does that apply in outer space, or is it simply not addressed?
It certainly does apply because, once again, Article 3 of the Outer Space Treaty allows for international custom to enter into the interpretation of the treaties. And as I've stated, this indeed has been allowed. But, Your Excellencies, if you are not satisfied with our humanitarian argument or consequences of humanitarian aid, we can look that URA still acted within the constructs of necessity. Now, the Caroline dispute says that a threat must be instant, overwhelming, leaving no choice of means, and no ability to deliberate in order to state to invoke necessity. We know that indeed SID-1 was an instant threat. If SPDR was to acknowledge the science behind gravity tractoring, they would know that in order to determine whether an action is necessary, that is, deflection is necessary, rather, they would have that URA must reach the asteroid and then conduct various tests in order to determine whether deflection is necessary. And URA did in fact follow these tests. Now, according to me, SPDR has said that we have been prejudicial, that we have not followed their particular method and we could have prevented this event. However, once again, SPDR has not acknowledged the scientific literature and understood.
Agent, had you consulted with them and allowed them to tell you that they didn't think it was going to work, do you think that would have obviated some of the problems?
Well, Your Excellency, consultation might not find a place within this particular scenario of necessity, as Rusty Schweikart and D.K. Yeomans has said that gravity tractoring, effective gravity tractoring, is indeed a function of start time. If URA was to even wait just an hour more, it would have thrown off calculations, and URA could have not conducted effective deflection because gravitational effectiveness is a duration of start time. More gravitational pull, the better ability we have to understand that this would miss. Now, SPDR has acknowledged an alternative method, but this has not been discussed in the scientific literature. Rather, the method that URA took was indeed the fact that was more studied in the scientific literature, especially in relation to the asteroid Apophis. This has been a theoretical study conducted by D.K. Yeomans for the B612 Foundation. So we can say that URA acted reasonably. May I finish my statement, Your Excellency? That URA did in fact act reasonably in deflecting SID-1. Therefore, I ask this court to exonerate URA from any liability associated with the damage done to drop gun by SID-1. Thank you.
Thank you, Agent. You may proceed when you're ready.
Mr. President, Your Excellencies, the URA asks the court to exonerate it for liability to the damage to the Canute-1 and Canute-2 space probes on the basis of the Liability Convention's Article 3 fault provisions. The URA is not at fault because it committed no wrongful act, either in landing on the Floyd 4 asteroid or in departing from the Floyd 4 asteroid. The URA has the right, as stated in Article 1 of the Outer Space Treaty, space and celestial bodies shall be free for all states to use and explore. And Your Excellencies, this is the relevant law contrary to any pre-litigation statements by either party. This article does not leave us to speculate on how it applies to the instant case, but rather it says, and there shall be free access to all areas of celestial bodies. The burden is on SPIDER to show that there is an Article 9 duty which supersedes the requirements in Article 1. Now, Your Excellencies, SPIDER alleges that the URA had an affirmative responsibility to consult before it landed on the Floyd 4 asteroid. Now, Your Excellencies, this issue has been litigated before. SPIDER both says URA should not have landed, period, and they should have consulted. With regard to the bigger claim, in the Gabčíková case, there was an issue with regard to Hungary claiming that its own environmental assertion allowed it to derogate from the responsibilities under a treaty. Your Excellencies, this court said that science had to be proven reasonably certain. The other states did not have an obligation to allow for the rights and obligations under the treaty to be altered on the assertion of one state. Now, it is stipulated in the facts, in Compromise Paragraph 7, that the URA had sensed the asteroid itself. The URA was a technically competent actor that could examine the surface of the asteroid directly. Now, given that, there is a strong indication of the legality of the URA's initial landing. Further, even in maritime law, where there are specific treaties allowing for things such as exclusion zones around oil rigs, which there is no specific treaty on that point for outer space, even in maritime law, Judge Manfred Locke stated that if a state had a preferential right to a certain area on the high seas, which that is a reference to treaties which do not apply to outer space, but even in maritime law, which specifically acknowledges preferential rights, that does not translate into a right to unilaterally exclude other states. According to Judge Manfred Locke in the United Kingdom versus Iceland, a state which has a preferential right on the high seas cannot itself unilaterally determine the extent and obligations of those obligations.
Agent, could we return to space law, though?
Yes, Your Excellency.
You said that the article on obligation, the right of a state for free exploration and use is it sounds like unfettered in your view, and yet the parties have argued that you cannot do so you must do so with due regard to harmful interference to the activities of other states. You have not really addressed how you could do that without looking at SPIDER's interest that has already landed on this celestial body.
Yes, Your Excellency. See, there is a duty to show due regard to SPIDER. However, SPIDER has not shown that, with regard to Canute-1, there was any prejudice to SPIDER based on the landing of the Tyro spacecraft. Your Excellency, the only damage to Canute-1 flowed, the URA concedes causation. It is clear that the URA takeoff caused the damage to Canute-1. However, under Article 3, it says that there shall be no liability unless there is fault. Now, Your Excellencies, once it was discovered that there was an emergency in the form of the SID-1 asteroid, the URA scrapped a possibly commercially viable mission in 25 days. Now, I think that answers Your Excellency's question with regard to the possibility.
But that was post hoc. The act of leaving the asteroid was before you knew what the commercial potential was of SID-1.
Oh, Your Excellency, in a way that's the point. The point is that there was a known commercial benefit to be derived from the Floyd 4 asteroid. The URA gave that up because its primary concern was deflecting SID-1. Certainly a speculative potential to profit from SID-1, if economics were the consideration, would be completely outweighed from the concrete position of the craft on the Floyd 4 asteroid. Now, Your Excellencies, with regard to the question of humanitarian law is general international law, and it is indeed part of the outer space treaties. Your Excellencies, as co-agent referenced, there is Article 98 in UNCLOS, which does impose a duty to proceed with all possible speed on a ship if it finds out another ship is in an emergency. Now, Your Excellencies, this duty is owed to the sailors. It is not owed to the spacecraft. And we see this paralleled in Article 5 of the Outer Space Treaty. In Article 5, there's a duty to help astronauts in distress. Now, Your Excellencies, if you think that this clause is ambiguous, we may have recourse under Vienna Convention Article 32. We may have recourse to supplemental means of interpretation. Now, Your Excellencies, this was discussed in the preparation of the Liability Convention. The intent of this was to extend, this is the American delegate's interpretation, at the close of the Outer Space Treaty. Article 5 and Article 9, the goal was to extend the same regard for life and limb that was owed to mariners on the sea and take that concept and extend it to space. Now, we need not limit ourselves to the Outer Space Treaty. We may look at the Rescue and Return Agreement, which provides a, on its face, distinction between people and property. People, if people crash on the Earth, the astronauts must be returned free of charge. However, the same rule does not apply for the spacecraft. States must pay to get their spacecraft back. Now, Your Excellencies, once again, if this seems ambiguous on its face, or if it seems that there is too much a logical leap in the analysis taken here, we can have recourse to the Travaux Préparatoires, in which it was stated it would not be appropriate to apply the same standard to people and property because, and this is a verbatim quote, because of the humanitarian concerns underlying the treaty. Now, Your Excellencies, the point here is not to merely show you a collection of random quotes from the treaty. The point is to show that there is an underlying rule of international law which shows that people are worth more than property. And the result in this case, Your Excellency, is that a state acted reasonably and acted rightfully when it scrapped its own potential to profit off of Floyd 4 in order to divert the asteroid, or at least get its craft to position. Doing so at the risk to another spacecraft was reasonable.
Who are the people that are trying to be helped?
Your Excellency, the people that the URA is trying to help are all the people on the basin of the cold ocean. In the present case, gravity...
Have they been in space?
Your Excellency, with regard to citing the space treaties, the point is not to show that they are astronauts or to say that the treaties apply directly. Rather, it is to show the underlying rules of reasonableness and the underlying humanitarian concerns which underlie both law in space and on the surface of the Earth.
But Agent, you cited the Return and Rescue Agreement. And the Return and Rescue Agreement specifically addresses astronauts as the envoys of all mankind. If people have never left the surface of the Earth, is it the same treaty that applies?
Your Excellency, that treaty does not apply. It is merely to show the general rule of law by showing how it is consistent between different treaties. The practice of states is what is relevant for showing customary international law. And when we see consistency among the treaties, there is a strong presumption that there is a customary norm involved.
But Agent, what is the principle in international law that would require a risky activity in a hostile environment done for possibly commercial reasons or commercial interest or testing of technologies? Where's the principle that allows that to be the basis for humanitarian action that would prevent damage to people on Earth?
Right. The point I was trying to make, Your Excellency, was simply to justify putting the canoed craft at risk. However, with regard to the situation on Earth,
Correct, you did say that.
It is an application to the facts. In order to gravity tractor successfully, the gravity tractoring efficiency, as stipulated by Russell Schreikart, who is the expert on the subject, getting the craft in place is necessary in order to receive transponder data from the spacecraft in order to better triangulate the orbit of the asteroid and its precise location in order to determine whether deflection is necessary.
Agent, in what year did Mr. Schreikart write the material that you are relying upon?
He wrote some of it in 2006. He's written more of it in 2008. These are multiple articles with overlapping content.
And in what year did the event of the instant case occur?
The event in the instant case occurred in the 2020s. However,
And the technology did not change that whole time?
Your Excellency, there is a dearth of stipulated documents or of documents which have been uncovered, so we have to rely on the documents which we have. It is unfortunate we do not have more. And Your Excellency, it is true that the URA had begun gravity tractoring testing. However, there's no evidence that they had not tested it in the rear position. They had tested it in terms of forward tractoring. So With regard to the damage to Canoe 1, it was reasonable for the URA to attempt to save human lives by moving its spacecraft over to the asteroid. That justified the damage to Canoe 1. With regard to Canoe 2, there are two issues. One, causation. As co-counsel has pointed out, the burden is on the state stipulating a fact or arguing a fact to show that fact exists, and a mere correlation of expected harm is not enough to prove causation. In this case, Spider was engaging in inherently risky activity. I point the court to the Philae mission in 2014, in which a spacecraft attempted to dock to a low-gravity object. It attempted to dock, bounced 3 times, hit a cliff, and then was unusable after that point. The type of damage Canoe 2 suffered is both a general risk from operating in space and a risk which might be expected because, as stipulated in Compromise paragraph 13, it had suffered multiple glitches. There was nothing in the compromise indicated that was completely fixed. And further, Spider was racing the URA to get to the asteroid. Now, that is not illegal. Spider has every right to engage in a space race. However, the damages which flow, it assumes some risk for its
Agent,
conduct.
define space race, please.
Oh, Your Excellency, we're simply pointing out that Spider has the right to try and get its craft on the surface first. That's not a wrong. The point here is not to show that Spider acted wrongfully at any point. Merely that they assumed a degree of risk for their inherently risky activity and for their glitch-ridden spacecraft. Now, Your Excellency, with regard to altering the surface, Spider's own conduct indicates that it is legal. It is stipulated in the facts that the Canoe 1 spacecraft anchored onto the surface. Anchoring onto the surface is an inherent part of docking to asteroids. Now, Your Excellencies, Spider has indicated that they intended to use their much larger Canoe 2 spacecraft to put it on the surface of the asteroid to mine. They are trying to exclude and keep the URA from doing the exact same things that they wanted to do with their own spacecraft. This is starting to sound like an appropriation, given that, as indicated in the Travaux Preparatoires, Article 1 is designed to give effect to Article 2. So when a state is attempting to...
It's starting to sound like an appropriation. Please define appropriation.
Your Excellency, when a state denies another state the use of a celestial body, Your Excellency, that their legal posture starts to sound like a de facto appropriation, because Article 1 is designed to interpret Article 2 of the Outer Space Treaty. So when free access is denied, now we're not saying Spider was in breach because they didn't actually enforce this, but it indicates that their legal posture is inaccurate. The legal posture in which they are asserting no one else had the right to land there is wrong, given that they had shown by their own conduct it was legal to modify the surface.
But Agent, regardless of whether they're attempting to appropriate or not, are you saying that there's that the damage caused to the spacecraft by your spacecraft leaving the surface of the asteroid was not the cause of the damage to the spacecraft?
Two points, Your Excellency. One, we're arguing that can't be proven. Oh, with Canoe 1, we concede causation. We're simply arguing...
I'm sorry, Canoe 2.
With Canoe 1, we're simply arguing about rightfulness. With Canoe 2, we do not concede causation, and we do not concede that the activity of altering a surface during a docking operation was wrongful.
But it's a small asteroid, and there's limited space to land. You can finish your answer.
Your Excellencies, it is a small asteroid, but even relatively small celestial bodies are something that states have a right to access. And for these reasons, we ask that the court exonerate the URA for damages to Canoe 1 and Canoe 2.
Okay, thank you. Okay, rebuttal. URA.
Your Excellencies, may it please the court, I have 2 brief points of rebuttal with respect to both issues of Agent Opposite's argument. Agent Opposites invoke certain affirmative offenses. They claim that their Adventura's activities were necessary, there was a sense of urgency, even that their activities prevented greater damages. However, if the court would permit a colloquial analogy, if I protect my home from a flood at the expense of my neighbor's home, I'm not off the hook for that liability. Specifically, the International Law Commission, in its codification of the doctrine of state responsibility, said that the invocation of a circumstance precluding wrongfulness is without prejudice to the question of compensation for any material loss caused by the act in question. Therefore, Adventura still must compensate Spider for the damages caused. With respect then, second, to the burden of proof, Agents Opposite assert the finding from Pulp Mills that a claimant must bring a prima facie case. Spider does not contest that. However, once a prima facie case has been brought before this court, the burden of proof shifts. I would point this court to Corfu Channel. Specifically, the court stated that indirect evidence must be regarded as of special weight when it is based on a series of facts linked together, leading logically to a single conclusion. And specifically, where a state is the victim of the harms, it gets more liberal recourse to inferences of fact and circumstantial evidence. This is why it was on Albania in that case to present the evidence before the court when it was the state that had all of the factual conclusions that could be determined from that circumstance, and not the applicant state of the United Kingdom. Your Excellencies, for these reasons, we ask this court to hold Aventura liable for both the damages to Dropcom, may I conclude, and the damages to Spider's spacecraft. Thank you.
Agent for the respondent.
Just 2 points. First, with regard to the implicit invocation of Article 27, which indicates there are some circumstances in which a state can invoke necessity and still be held liable. The cases on the subject appear to indicate that is more for cases in which a state has a continuing breach after first invoking necessity, not for a case in which a state invokes necessity and then acts. Now, with regard to the URA's claim of necessity with regard to the damage to the surface, it is simply a matter of the science. The reason notice was not given earlier is that the URA didn't know it was going to deflect until it had the transponder in place. That is a component of deflection. Now, as this court indicated in the Norwegian fisheries case, the United Kingdom was stated to be a sophisticated state which should know that actions were taking place prejudicial to its rights with regard to fisheries delimitation. The relevant principle here is Spider was a sophisticated state involved in neo-deflection activities. If they believed the URA was engaging in actions prejudicial to their rights, they had an affirmative duty to complain. Now, with regard to the specifics, again, as noted, the forward position is the one that has been tested. Given that the URA found itself in the middle of a once in 100 years, the Tunguska event is the nearest event on question that happened over 100 years ago with a smaller asteroid, given that it found itself in this situation, it acted reasonably to use the method that had been studied in detail, and because gravity tracking is a function of start time, it was reasonable in doing so as fast as possible. Thank you, Your Excellencies.
All right, the case is submitted. Thank you.
If we can have all the spectators head over to the Weir Student Center, 12th floor, that's where the reception will be. We'll announce all of the award winners at the reception very shortly. Teams can stay here. I'd like to get some pictures with the judges and the teams, and then the teams will leave and the judges will deliberate in this room. So thank you.
We've been here. We have been here.
Can you guys sit back down? Oh, sit back down. There's a problem.
All right, okay. Then I'll head back down this way and see you and say goodbye.
Skip, do you want the down front? You get judges and
The judges will be here and do one team at a time. So one team with the judges and then the other team with the judges. And then maybe one group shot.
Standing in front.
You want us to stay here?
No, I don't want to
come here.
And should we just all line up right here?
Yeah, let's do this team first with the judges, then that team with the judges, and then we'll get everybody.
Excuse me. Say that again.
Yes,
Yes.
you're there, team next to you or whatever works.
Put the long pole in the middle of the tent.
The photographer will direct you from here.
Yeah, thank you.
I think we should put the students in.
Yes.
Okay, that sounds good.
There you go.
Yeah.
Or he wants to put it in front, he puts it in front of us, right?
Jay, you're big enough, you can be behind it.
Good one more. Okay.
All right,
Switch it out.
so switch teams?
Oh, you had three? Yeah. Will you trade off during the preliminary? Yes, sir. Please. That'll work.
Can you get everybody in there?
Just put them in the center.
There you go, that's good. Excellent, very photogenic.
Okay, so let's try to
Yeah,
get
yeah.
all
Yeah.
teams, both teams together
Group hug.
and the judges and.
What are you doing?
Yeah, forward.
Oh. I'm gonna be more central. I have a woman on one side.
I'm over here.
Separate but equal.
I can't believe you said that. It's like there's something from here.
Only
Good,
thing
got
you
it?
got.
Got it? Okay, so the students are, can go over to the nearest 12th floor and have a glass of wine. and-
Sorry.
Good job, very short.
I missed somebody's.
There's a reception.
Thank you, Jim.
So we're building it here.
Yes.
Thank you. See what I mean about judging the ones that kept getting confused on the satellites?
No,
It wasn't too fatal.
Yeah, no, and those were two of the best arguments that were both on, so just let you know.
Yeah,
On both sides, they were both,
very close.
they were both right.
I get a very big kick out of seeing two coaches in the back.
Yeah.
Wow, I'm glad Skip's here for this.
I'm glad that It's so hot this way all the time.
So Mississippi Field we can't avoid it. Jackie stood in the back and Steve
Yeah,
stood in the
I
back. So
know.
now that was a mistake,
Well,
putting the coaches there.
you know, they're always there, you know, I mean.
For the photographs, I mean. They were the ones who didn't leave.
Oh,
Doesn't matter. I mean, I remember Brad instantly because he came up to me at the reception about 3 weeks ago and reminded me he had argued. Didn't he win the best oralist last year? Or?
I don't remember.
Didn't he win that? He didn't.
I don't remember.
You did argue.
He argued, yeah. I think he was on the winning team is what it was. Didn't Georgetown win last year?
They didn't, no.
Florida.
Florida State.
So they lost.
Florida State. Florida State.
Yeah,
But he was in the finals because I saw him.
he was, he
Yeah.
was in the finals.
Yeah.
Second year. You can participate again with the regional organizers.
Permission.
Consent.
Right. He said he
as
was
long as
participating.
you did not win.
He told me he was participating because he's
This
interning.
student participated
Yeah.
more too.
Did he?
But
He didn't.
the judges.
But he didn't make it to the finals.
Coaches, they figure it
Because I
out.
didn't know, but I couldn't tell that they didn't make it to the finals, so I'd never seen these kids. Mississippi.
It was a different team. There was one guy that was the same.
No, I can't remember. I think they did because I think they came in second. We always would miss by like less than a point.
Mississippi?
Yeah, I know. It's always like that.
And it's
Well,
like,
this is really close. So these were the best arguments. That's interesting. I didn't find it any, clearly exceptional. I mean, I have somebody I think is the best oralist, but I didn't have somebody, it wasn't like